well, so apparently I get this in, what, 14-minute slots, and I think that what they've been doing lately, somebody's been monitoring my time, and they always cut me off 1 minute short of what would have been my time unit. I think it's their snarky way of trying to prove a point, and you've proven your point, because I've been allotting a minute for the accounting, and I'm just disclosing that, so you're not going to be able to get away with that. I don't like rounding up or down, because that's, it's just not very good timekeeping, and I am that good with time. So I would advise you to cease and desist, but I'll keep it to 14 minutes just to be consistent with what I think you're trying to approximate. Now, let me finish what I was saying here, which is that it also speaks to concerns specifically regarding the database problem regarding other DOJ and law enforcement efforts. This brings up contentions as I outlined in my responses to Maryland versus King. Yeah, you remember that, right? And there's been several versions of that, some of which have been stolen, right? Even before they got to the audio file. But don't worry, I got my points. I got them all that I need. All right. So let's continue. What do we got here? Next, we had a consideration here regarding to perform a function of an immigration officer in relation to the investigation, apprehension, or detention in the United States. What? This speaks specifically to matters regarding the distinction of interstate transport as being compliant with laws against trafficking and racketeering, as well as cross border considerations that are specifically a challenge here and not just related to immigration law, but other laws related to cross border transport of goods and the implications concerning smuggling and or considerations of, for instance, the tax credits provided to cross border transport using military vehicles as part of the proposed carbon dividend trust from 2019. With the changes to laws like those in Texas Insurance Code, focusing on transportation specifically regarding insurance, and with the Texas Government Code changes regarding their Transportation Commission activities that went into effect on September 1st, 2019, the other matters related to bidding and confidentiality of contract bidding need to be addressed. That will necessarily include regard for transportation for alleged medical services, including mental health care, per the changes to the Texas Government Code regarding mental health from September 1st, 2019, as well. See arguments regarding distribution after acquisition and procurement. That would have been part of my original habeas corpus or writ for habeas corpus. And there was the information that he discusses. Form I-286. I asked, the form is bonded to what? Now, my experience has been that, for instance, when there's a public comment period about a form, that providing a public comment period does something in terms of appropriations related to that form and the use of that form. It still as yet have not been answered. So if in fact there is this form that is part of these particular administrative processes, this is a very key element in terms of filling out this form, how this form is treated, and the other matters related to the specific case involved or the hearing involved and the bonding on it, so as to assure that that form is not misused or used in any sort of other processes that could exacerbate the context here, which I bring up right here when it talks about if the detainee prevails, he or she is entitled to a bond determination. This is talking about the capacity for one to challenge a detention mandate. And I say, does this mean that all determinations regarding bond are referenced to or through the exercise of the option to challenge via a Joseph hearing? He discusses something I had not heard of before, that when you're in detention, everyone is entitled to a so-called Joseph hearing. This is not something I had been apprised of before, but apparently it refers to a specific case. Then I say, exercising the option to challenge is different and distinct from whether or not the challenge prevails. That may then speak to whether the bond on the form that makes the determination itself becomes one of a number of options, or if that as an option is impacted by the challenge and whether or not it prevails, and possibly impacts the original bond in establishing another bond relationship. If these processes are being used in connection with bidding, then that becomes more of a concern. So the overriding problem here is the concern of the speculative processes that go into when and how one is allowed to be processed. And specifically here, there is a letter requiring the reports to an ICE facility for detention and deportation. This implies that the person arrives at the behest of their own transport, but is expected to bring with them items that can be inventoried. This is identified as a bag and baggage letter. And then there's another one where they discuss one who fails to report as classified by ICE and the circuit courts as a fugitive. Then I say fugitive from which jurisdiction. This could impact the terms onto which they arrive back in their country of origin if they are deported, and or the implications of their removal insofar as they pass through another country on their way either to or from the country of origin. Remember, the major problem with people who were trafficked was that they get picked up at the airport or the ports to which they are returned to be re-trafficked, either to the same country or different one. Now, this harkens back to allegations or considerations, including court proceedings regarding trafficking trials that were happening in the mid to late 90s after there was a comprehensive legislation passed regarding support for victims of trafficking. One of the major concerns had to do with the airport and or the port. And once you're deported and then you get back there, who picks you up at the airport and how is that handled? Because a lot of times people would being sent back, they'd get to the airport, they'd get picked up at the airport, and then they'd just be re-trafficked, either to the same country, maybe to another city, or to a different country altogether. And so the question of transport is the key matter here, which also then talks to the asylum procedures and due process. And then this information that is in the memorandum, he quotes the memorandum, but discussing, as I say, discussing a reset and a rebuilding is of concern. He quotes the memorandum as discussing reset on immigration law, but then rebuilding the processes. If you read executive orders, these kinds of determinants are very, very specific. So the use of these words is something that has to be taken into context, especially with the recent efforts associated with the role transportation has been playing in the recent package they're trying to get approved concerning infrastructure. Then it says that it quotes the memorandum talking about another memorandum talking about 3 DHS enforcement priorities, national security. It's number 1, and it says individuals who have engaged in or are suspected of terrorism or espionage. And then I say this brings up concerns regarding the National Transitional Authority Authorization Act 2017 and changes to the 1958 National Space Administration Act regarding charges of disloyalty being available for prosecution by the Attorney General as a form of espionage, as well as the concurrent problems with the abuse of disability and space vehicle exceptions that go back to the onset of the Affordable Care Act, as well as the 2016 election accusations of Russian hacking and spying have focused on foreign-born people, at least publicly. This is specifically of concern because the day that this opinion was issued, there was a federal registered notice regarding intellectual property rights for people that were foreign-born. And so the specific date and timing and the elements regarding espionage and calling out the fact that suspicion of espionage is being addressed within a context of dealing with immigration at this level brings up a whole bunch of outstanding considerations that have not been appropriately addressed, especially in the last 5 years. And then there's this reference to November 1st of 2020, where he talks about unlawful entry to the country after November 1st of 2020. And I say this would be 1 year and 1 day after the executive order on contracting that was issued by Donald Trump, where previous contracts had been canceled, and then there was a period of time that was supposed to commence for new contracts to be able to be put into effect, as well as the Department of State audit regarding noncompliance with the Data Act. On October 31st, 2019, there was an audit that was made public for the Department of State that discussed how the Department of State, during a specific period of time where it had an audit, had just not been complying with legislation around reporting origin of information as part of transactions, as well as the source of transactions from within the United States that were going overseas. Now, this was just for one period of time that was specifically looked at, including understanding that they were not dating the actual dates that the events occurred, and instead allowing for all transactions to be aggregated into a system where they were all given the same date. which is completely not only non-compliant with the Data Act, but speaks to many, many considerations going on right now, specifically with COVID-19, but also in consideration of any intercession with or through the Department of State, which necessarily is going to happen when considering asylum claims. And insofar as that has not been addressed since October 31st of 2019, the fact that this executive order specifically references the November 1st of 2020, it's a year and a day. And a year and a day standard in criminal cases is very different than in other considerations. Then it goes on to talk here about Section 101A43 of the Immigration and Nationality Act. I say this is a very specific exception for the other reference points. This consideration of 43 in the metric 43, this specific reference to this code of law without other context brings up a concern, especially insofar as other things end up commencing. This is talking about has been given a meaningful opportunity to access counsel prior to signing the waiver. This is the thing. This is very important. This is concerning because of the implications of another proceeding that's going on that I contend is actually being disabused by people that identify themselves as members of the State Bar of Texas. But this understanding of this waiver as potentially being used in some sort of derivative action or as a form of almost insurance. Insofar as I've charged that what is happening is that people that are being engaged in these, including litigious process, but also administrative processes regarding deportation or immigration proceedings at the U.S.-Mexico border right now, that has been already identified specifically as correlating with major large-scale bond issues that I contend are acts of securities fraud and evidence of trafficking, but that also are ongoing to, in concurrence to processes to try to cover up for crime and instead leverage other kinds of issues as if they're civil rights issues instead of considering them as crime, are these waivers that are being offered to people to sign as part of this one-time matter being used in some sort of derivative action or in some other non-explicit action on behalf of state actors that otherwise believe they're qualified for immunity based upon the performance of their job. Now, because I understand here, they're talking here, and then talking about another priority regarding the number 2, inclusion of currently qualifying members of criminal gangs and transnational criminal organizations as presumed enforcement priorities. And this goes into the considerations about those previously mentioned waivers, but also the implications regarding the specific relationship to public safety. And the specifics around public safety as opposed to some other kind of matter, including in consideration of the fact of the understanding that many of these cases were engaged, or many of the efforts related to the border crisis, including those under the Trump era, is going all the way back to the ban on certain countries that was originally identified as a Muslim ban, commenced prior to COVID-19. But have been ongoing during a time frame wherein COVID-19 then became a material issue, including in consideration of how healthcare issues connected to those that are at the U.S.-Mexico border, trying to be determined for whether or not they can enter, has been handled. I'm going to bring specific notice to an event that occurred at the end of 2018 into the beginning of 2019, specifically regarding allegations of a specific kind of bacterial infection that was impacting people at a border facility where a certain number of children were reported as having died in a specific period of time. I contend that specific report was used in illegal speculation, or rather illegal hedging, connected to attempting to manipulate issues related to what's going on at the U.S.-Mexico border for matters that were not about what was going on at the U.S.-Mexico border, but rather were trying to exploit it for political leverage in other areas. That's to this day have not been contended with, which will get into the more discussion and explication of the criminal implications that are at work here that are being obscured by whatever else is going on with the particular manner in which these immigration concerns are being handled.